May it please, Your Lordship. My Lord, on 17/9/2024, Your Lordship was pleased to enlarge the person on bail to the satisfaction. It ought to have been, my Lord, Special Judge Karimganj. Inadvertently, it was typed as Chief Judicial Magistrate Karimganj. So, my Lord, we are filing a petition. Your Lordship, kindly take it at 2 p.m. now.
No, this bank will not.
Then, as soon as, my Lord, we can place it before Your Lordship.
Up to one, anyhow, we can.
My Lord. Okay.
Otherwise,
All right. Obliged.
Well, with the consent of the respondent, madam, my friend, item number 3. Yes, they appeared for the first time. It will be taken up on 29th October, madam.
item number 3,
Item number 3.
Item number 3.
you have taken consent of the
Not so
Yes,
much.
I am for the respondent.
There is an interim that may continue.
interim was there.
Interim.
The consent of the other side. And one interim become it's after it will be tested after vacation only.
Yes, my lord. On kindly fix it that, my lord. On 29, my lord.
29
See,
October.
29 October, madam.
October.
Obliged.
Now, please, Your Lordship. Lordship, the concern of the other side, I beg to mention item number 7, Your Lordship. In this matter, additional AG, Mr. P.N. Goswami will appear, Your Lordship. Item may be taken up after vacation, Lordship. I've taken the concern of the other side.
We are for the petitioner, my lord. We are on interim, my lord.
you are for the petitioner.
Yes, my lord.
Interim order was on 4/3.
Yes, my lord. On 4/3/24, my lord.
So you're saying that additional AG
AG
will
will
appear.
appear. Yes, Your Lordship. Mr. P.N. Goswami will appear in this matter, Your Lordship.
Huh?
Mr. P.N. Goswami will appear.
Parties to appear in the application. Also, parties to be done to complete appeal on behalf of as additional AG, Mr. P.N. Goswami, and subject to concerning conflict. Mr. Goswami is not in a position to appear before this court. Stop there. List matter. After vacation, it will be listed. List after vacation. Your interim was there, no?
There is interim. Yes, my lord.
May please, yes, Sir Lordship. Lordship, with the consent of other side, I beg to mention item number 5, Lord. Lordship, this matter may come up after vacation, Lord.
You are for the other side?
Respondent, madam. Respondent number 2.
With the consent of the other side, Mr. Swenson, you can counsel for the additional bid for an agreement. Prayer allowed. It's the matter of application. Okay, it will be listed.
Interim order is there.
Interim
Interim order.
order was there. Interim order be continued till next time.
May I please, Your Lordship? Item number 23. One affidavit has been filed for respondent number 2 here. So I may be
23.
item number 23.
Yes.
So one affidavit has been filed for respondent number 2. So I may be allowed to call for the copy. Or
Then it can be taken up. Matter.
Yeah.
Okay. Okay, we'll try.
Made this is a Lordship. Lordship, I am praying for listing of a bail hearing matter attending to Lordship's bench, madam. Bail hearing
Now
matter.
you approach, it can be, but you approach the registry, it may be fixed because I'm not taking the regular
Exactly,
bench
madam.
effect.
That is the difficulty, madam. That is why we are.
We don't have any alternative because I'm not taking the regular benches at present. So you can approach, then definitely even if we have the division bench, matter may be listed if time permits, definitely. So you can approach it.
May I please, Lord? My lord, item number 6 may be attended today.
6.
Item number 6, my lord, I am for the respondent number 2 and 3, and I have already taken the consent of the petitioner side.
You are for the respondent.
Yes. Respondent number 2 and 3.
You are MS M. Khatun.
M.
Heard MS M. Khatun the learned counsel for the petition. And with the consent of the
After
other side,
vacation,
let petitioner take for an adjournment. You have taken consent
yes, ma'am.
after vacation?
After vacation.
Where allow this stuff.
Oh, let's
Lordship, the petitioner is seeking to withdraw this petition. The occasion that he is going to appear before the learned trial court
Acha.
before the next hearing date.
Also.
So that is the reason like we want to withdraw this petition.
No problem. Her Mr. W.R. Reddy, the learned counsel for the petition. And also heard yeah, learned additional people come and learned senior counsel. It is submitted by Mr. Mehdi that as per the instructions of his client, he wants to withdraw the same. Okay, it will be disposed on with.
Obliged, sir.
Wait, please. Wait, please, Your Lordship.
Yes,
Yes, in this matter, my lord, I am behind the bar for last 2 years, 28 days, my lord.
2 years, 8 days.
28 days, as on today, my lord.
Oh.
And earlier, Lordship was pleased.
Charged on what is the stage of the case at present?
My lord, out of 10 witnesses, 4 were examined.
4 days.
4 examined, my lord. And my lord, last witnesses were examined after 1 year, 2 months, my lord. That PW4, my lord. PW3 was examined in the month of 18/7/2023, my lord. And thereafter, the PW4 was examined on 6/9/2024. 6/9/2024. So, my lord, our
Scan copy of the
yes, my lord.
Yes, obviously, we will
After
scan copy of the particular along with the status report. You want any fixed date?
after vacation, my lord,
After vacation, any date to
any date.
scan copy of the LC along with the status report. Present status report.
registry will bring, my lord.
Registry.
Registry will
It will
bring.
be routed to registry, my lord.
No, registry will call for it.
Yes.
Registry will do the needful. We're listing 2910 Koito Penny. 2910. After vacation, 2910.
29, my lord. Give them.
That's fine.
Actually, 4.
Petitioner is absent.
Petitioner is absent on call. Pardon, done it additional. And after one. After one. Okay, we're listing it after one.
Fine.
Your Lordship.
Yes, 48.
Yes.
Yes.
Item number 8.
Eight. No, just like a short issue. Yes, the vehicle was seized. Sum of rupees 10,50,000 was seized, and passport was seized. Concerning this case, case is basically registered Assam Games and Betting Act, allegation of IPL betting. This petitioner was arrested. Subsequently, he was released. We filed an application for Lami Surgeon for release of the vehicle, passport, and money. Now, the Lami CGM was pleased to reject our application. We are before this honorable court by filing a 2 application. one concerning my vehicle, and second, this instant application. Now. So for the vehicle is concerned, this honorable court already released the vehicle and allowed the revision application. Now this matter is pending. So for the
This is
passport
for
is
release of money.
money and passport. So for the passport is concerned, my lord, that passport was released by the police on their own motion. So we are not having any grievance for the passport is concerned. Now we are only concerning the, the money. Now the two things, lordship may kindly be considered. Number one is that the money was seized from my house, not from any betting place. So it's my in the Godrej I kept the money, my lord, and from the Godrej they seized the money one. That is not relating to any betting place. This is number one. Number two, sorry, my lord. Sorry, my lord. Number two is, which most important, that is, my lord, that this money has been accounted in the income tax. The income tax returns were seized by the investigation officials. All the income tax returns, my individual, my HUF firm. I'm just, there is in the perhaps in the city, but I'm just placed my income tax. As per the return, my lord, the cash in hand, as per the return, is 19 lakhs. So the money has been accounted in the income tax department. So there, kindly have a look, my lord.
Lordship, before my learned friend proceeds further, may I pray your Lordship, a report from the IOB called for your Lordship.
That has been called for by the learned CGM, and they said that they have an objection. So therefore, on the basis of that, in the impugned order itself, it has been reflected that the matter has been. And this honorable court, I moved this application, my lord, long before 3rd of July, and the case diary has been called for with the report. And perhaps
So
my
received the case diary first.
No,
yes, absolutely. On the last occasion also.
On which date? Which date it has come?
Last
Yeah.
occasion was 21A. It is comes.
Doesn't remain for so long time, Lordship. 21/8, we are in September 23rd. So
My lord,
1 month.
I am sorry to mention here in your lordship
Then
that the
21/8, it was not heard.
no.
No.
It was-
not on that. The CD was received on.
Yes. The CD was received and the matter was listed before the Honorable Justice Mr. Nayar. And when the hearing was took place, my lord, the learned public prosecutor, additional public prosecutor, seek for a time, and thereafter the matter was again listed on the Monday. It was listed on Friday, 21st. Then the matter has been dragged, Your Honor. Now the matter has been listed before this honorable court. Now the CD has been remained not 21st. The CD has been received before that. Before that is a 5/8.
Lordship,
The
to
matter
verify
was
with the
listed-
office. Generally, we don't keep CDs for long, my lord, in the office.
If you can make any inquiry whether it is still there.
Lordship, problem is that all the staff have been reshuffled there. So today it may not be possible, my lord. Can it be on Friday?
Tomorrow, madam. No. I'm Lordship, I am aware. I'm from the outside. My sister also know that tomorrow matter, because your
Day
Lordship,
after that?
unnecessary the matter has been dragged for one. In the earlier occasion, the learned PP says that it requires some time for perusal.
Yes, it's okay.
When is
Tomorrow, if
the-
suppose CD is already there, then definitely it can be listed tomorrow.
Lost.
But if it is not there,
Then Lordship,
Day
tomorrow
after
will
Corridor?
no, tomorrow will arrange the date, Your Lordship. Letter will be listed for tomorrow, Your Lordship. The CD is here in the office. Perhaps if it is not there, then matter may be listed accordingly, madam.
Because the staff have been reshuffled, my lord, in our office. So
That is
we
their
are
problem, my
facing.
lord. Why the
No, that is
petitioner
there.
can be-
So you have come after 1 month or so. Do you expect the CDs will be there in the office?
I'm not expecting such a submission from my sister, Your Worship. The matter has been dragged only for the prosecution side.
yes, I can
Keeping the and the order is reflected, my lord. My lord, kindly have a peruse that they are continuously from 3rd of July they are seeking time. Whether they will pay the interest, my lord. If they agreed at the rate of 12%, they have to pay the interest. I have no objection. Matter may be
You
posted
have to
for a.
make RBI as a party respondent of finance
No,
department.
no, I'm just.
For
I'm
interest.
No, no.
Reducing interest.
No, no. Why you? Nothing more, Your Honor. Lordship is kindly see that the matter.
If CD is available, I have no hesitation, my lord. Matter may be taken up tomorrow, but I have doubts, my lord. So instead of tomorrow, can it be on Wednesday? I'm making that
I'm not.
submission.
I'm on
You are-
Wednesday.
you are
I will be
here,
available.
say?
If it is tomorrow, am I not? I'm very, very. I'm
No, no, it's
that
okay. Nah, are you on till tomorrow?
tomorrow I am there.
Wednesday?
Wednesday I am not here. I have a matter at Calcutta. Lordship, I have to move tomorrow. My only suggestion, my lord, let the matter be fixed
The
tomorrow.
next week,
Let the matter be fixed tomorrow, Lordship. If CD is not available, then accordingly the matter may be fixed, Your Lordship. Yes.
You can just
Oh,
think about the matter. If it's
What is
problem is with the
difference?
office, my lord. Problem is with the office. All the
No,
stuff,
I have heard about that.
my lord.
This-
So that is the
this
problem,
and
my
all.
lord.
Perhaps, Mr. I'm just suggesting. Perhaps Mr. Parashar has handling the matter. Mr. Parashar has handling the matter.
Okay, I'll talk.
Huh? Pranjal also
Pranjal,
handling
no?
the matter.
Last time Pranjal
Yes,
bhai
yes.
Borivali thank you.
Parasar is out of station.
Pranjal is there. Last time Pranjal is there.
I was not there, so I am not aware
Yes,
of it.
yes, yes. Correct.
Pranjal bhai record
So I'm just requesting my sister, Your Lordship, just to consult with.
Okay, we'll be fixing it tomorrow, but
Tomorrow.
the
Yes,
position
yes,
is
yes.
only.
Oh, no, Pranjal is unavailable.
Fine, Mr.
Pranjal
Yes,
को
you have accepted that.
10 lakh टका का नहीं
And also
10
part
lakh टका कितना है?
Kipnia when additional PPT and senior counsel appearing for the state. From the record, it's seen that the PD was received on 1/8/2024, but additional PPI is not to see as to whether it's still lying in the office or not. It will be inquired as to whether it's still there in the office. It's according
इन्हीं
to
के जी में होगा
Panakali. So we are listing it tomorrow.
Yes. Grateful, man.
Mahakali Chotis.
Please, lady. This is a matter which has come up for admission for the first time. This appeal comes up for admission for the first time.
Okay.
It may be
It's appeal
admitted.
against conviction.
Yes, appeal against conviction. Section 366,
It's a-
376, and section
370.
It's the same.
Under section 42, it has been gone.
Yes.
Anyways, Srimati, one
Yes, Mr. Sarfaraz Nawaz's name is shown.
Yes.
Huh?
As legally.
Sarfaraz
He was appointed when the delay condemnation petition itself was being taken up by the Honorable
It's a
Court.
POXO matter. They are to be heard.
Okay, then we can admit the appeal
Admission.
and we'll issue the notice to the we'll call for the case here also.
If-
Now,
if direct-
now you are appearing.
Yes, yes. If your
The
leadership
earlier
directs,
occasion, who was there?
Mr. D.K. Bhattacharya was there. In the cause list,
What
leadership.
Mr. Sarfaraz Nawaz is appearing.
Yes, yes, he's appearing. On the last date also he appeared.
The respondent number two.
Yes, yes, he appeared. In the order whereby this Honorable Court had
What,
condoned
your
the.
condemnation was there.
Yes, yes.
Condemnation or not?
The condemnation, it's IA criminal number 20 of 2024.
Yes. If has already appeared in condemnation,
My lord.
it
His
is
name is shown in the cause list.
He was here.
Oh. And after some time,
I'll serve
let him
him a
come.
copy, your leadership. It may be admitted. I'll serve Mr. Nawaz a copy directly.
Nawaz was here, I think.
Yes, yes.
That's why just now.
He had come for item number 7. He inquired and he left.
Oh,
After some time, then he may be also be heard.
otherwise we can admit.
For admission.
Just issue a notice, then he will appear now. Next day it will be
Right.
okay. Heard Mr. You are Mr.
A. Gautam Miller.
A. Gautam, the learned counsel for the appellate, and also heard Ms. Ibn, the learned additional PP and learned senior counsel for the state respondent. This is an appeal under section so and so against the judgment and order of the judgment. Full stop. Appeal is admitted from hearing. Call for the elsewhere. Issue notice to the respondent number 2. However, it is seen that the name of Mr. S. Nawaz indicated is shown in the call list, who was appearing in the IA criminal 20 of 2024 for the respondent number 2. Mr. Nawaz may be intimated accordingly. Do not go to the Okay, we are calling for the, we are just, we are here we are issuing notice, but if Nawaz appears, then it's okay. Otherwise, we are issuing notice.
Yes, yes.
Nawaz already appears, then it's okay.
Yes.
I have
Very
written
great.
his name also.
Yes, grateful.
So it will be listed after 4 weeks. That is case diary record be called. I mean, LCR be called.
Scan copy of LC. Oh, conviction.
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 Grateful.
May I please, Your Honor? In this case diary was called for me.
Jail was called for.
Yes.
Okay. Yes, who is appearing?
CD is not available.
CD is not able.
Not available.
Interim may be continued, my lord.
Let it be after vacation, Lordship. He's on interim.
After vacation, any date?
Lordship, a date may be fixed, Lordship. It is on 22/10.
2210.
Lordship.
Yes, it can be 2010 available. CD is not available. Interim be continued next date. 2210. We are listing.
May I please, Your Lordship? As part of office note dated 19/9/24, await for service report upon respondent number 2, Lordship.
Since when this service is awaited, in fact?
We have taken fresh step on
You have taken?
6 September.
6 September. No?
Fresh step through district magistrate.
To district magistrate. Report is not yet come. No? Let it be awaited till next day. Otherwise,
Yes, Lordship.
you are MS.
I'm appearing on behalf of SCP Squads, KLR Yangthan.
Hard MS to appearing on behalf of Mr. SC response. Also hard MS as Bora. For SH Bora.
SH Bora.
SH Bora. The London appearing on behalf of the response. As per office note dated 10/9. No, 19/9/2024. Service report is neither the service report nor a card has been received for the respondent number 2. Let service be awaited till next date of receipt. It will be listed after vacation only.
Lordship.
List after vacation. Now the service seems to be completed on respondent number 2.
Lordship.
No one has appeared yet. It's a case
Petitioner
of
is
POCSO.
absent perhaps.
So we may suggest the registry to appoint the amicus,
Amicus curiae, Lordship.
amicus for the respondent number 2.
Lordship. In the meantime, notice should go to respondent number 2 through registry.
Pardon?
Notice should go to respondent number 2.
No, service on respondent number 2 was already completed, in fact.
Okay, completed. Then Lordship may appoint a
You can appoint.
Yes.
None appears for call for the appellate. Hard message for us, did not additional PPFA and lack of state respondent. It seems that the service is already completed on respondent number 2, but none appears for the representative respondent. Stop considering the nature of the offense. I find it proper to appoint Michael Security to represent the respondent number 2. The registry will do the needful and will also notify the amicus who will be appointed for the respondent. As chair has already dictated. Then it can be listed for hearing only.
Lordship.
Matter will be
Okay.
after vacation.
May I please, Your Lordship?
Yes.
My lord, this criminal division petition has been filed by wife, my lord, seeking, my lord, enhancement of his maintenance allowance. My lord, there is a problem, my lord. As per my lord, Rajnesh versus Neha, reported on 2021 to HCC, my lord, asset and liability has not been disclosed by both the party in the court below. May I pray, my lord, it may be disposed of in the light of, my lord, this judgment. Your lordship judgment order is here, my lord. My lord,
No, no. First of all, we need that you are for the wife.
wife, my lord. Wife has been given 2,000 and minor daughter, school-going minor daughter, she has been given only 1,000. Till 3,000 given.
What about the notice to the other side?
Yes.
My lord, notice, my lord.
We have
Notice
not
part,
taken steps.
I have taken step, my lord. My lord, he is not appearing, my lord.
Very
Because not, name is not reflected in the causes also, Lordship. The notice should go first, Lordship. Let them appear.
My lord, in the, my lord,
No, you have rightly submitted that Rajnesh Neha is required now, but the question is
yes,
that
my lord.
if he appears, then it will be easier for us to
Yes,
hear the
Lordship,
matter and
dispose of the
remand
matter.
back whatever.
If he
Yes.
appears,
in his absence,
if he
because
appears,
now see, you are here against the against the quantum of the
yes, my
area.
lord.
So obviously he should be here.
125
You take
proceeding
steps, or you have taken steps on only on 4/12/2020. Thereafter, yes,
Notice has been sent from this office.
yes, again on 29, you have taken steps. Is it a proper address where you have taken steps?
My lord, I think, my lord, this address has been taken from the, my lord, what has been in the court below, my lord.
Obviously, that is most probably the proper address also.
My lord, I think it is proper, my lord.
Then we have to wait for the otherwise.
Yes, the matter.
Obviously, it is the matter can be remanded back, can be disposed of, but in their presence only.
Yes.
Lord, let it be come after vacation, my lord.
Okay.
Immediately after vacation.
Ah.
The problem is that, my lord, she is not getting maintenance, my lord.
For that, have you filed any application before the
No, my lord.
learned trial court?
No, my lord.
Just file an application
My lord.
because it is in the execution stage. You can
My lord.
file.
My lord.
Take your grievances. Otherwise, if he doesn't pay anything, suppose, then it may be a case of even issuing warrant also. So you just
My lord, that's, my lord, an observation may be made, my lord.
no. How can be when he is not here?
Without
Heard Mr. A. Manna, the learned counsel for the petition. Also heard SH Boda, the learned additional PT, on behalf of the respondent. From the office note dated 20/09/2024, it is seen that services neither AD card nor service notice is returned back to the registry. Await till next set of listing. List accordingly uploaded. Next value for part of Mr. Manna, who has submitted that the present petitioner is not getting given a fiscal penny towards the maintenance. Is that. In that regard, the petitioner is at liberty to approach the trial court below with an appropriate application for seeking the area maintenance / the maintenance. I have once just made an observation. You can appear before with a proper application.
My lord, my lord.
Otherwise, we will list it application.
It may be come after vacation.
After vacation.
Obliged.
May I be the lordship? In this case, also, as per office note 10/9/2024 and 19/9/2024, service upon the respondent who is awaited, lordship.
Service is still awaited.
Lordship.
Scan copy was called, that is here.
Call for Lordship.
That is here.
That we have already received.
Yes, it's in with the records.
But Habis is awaited. We take steps on 31 September. Raise this and it on 10/9/2024. Lordship. That's my office.
This is caution of FIR charge sheet and all.
Lordship.
Anyways, they should appear. This is FIR registered under which sections? 354.
354. A and 54B.
Let them come. It can be taken through the OC if it is not served.
No, for the OC.
It can be true.
Lordship, I will take this step and order.
Oh.
For the OC, Lordship. For the OC, Lordship.
Through the jurisdictional, yes, OC
Ah.
of jurisdictional.
Obliged.
Hard Mr. N.J. Gogoi.
NJ.
Yeah, hard Mr. N.J. Gogoi, the learned counsel for the petition. Also hard MS Ejna, the learned VP.
Please.
For the state. It was from the office post 99/2024. It is seen that this is still available for the respondent number in that context. Mr. Gogoi submitted that he may be allowed to take fresh steps. He should press notice on the respond number 2.
Phone number
to OC of his jurisdiction police station.
House number.
Police matter accordingly. Okay, you take steps to jurisdictional police station OC.
And he can also check the if there are some other address in the.
Also, we take step as per the address of the FIR, Lordship.
FIR he may not be there if
The phone number is there, Lordship.
You can try to collect the proper or present address.
Lordship.
If it can be possible, then through that address only you can take steps. Okay. So we are listing it after vacation only.
Obliged.
okay, 70.
Lord, steps were taken on 2/4/2024.
2/4.
2/4/24. There is only delay of 64 days. As we have mentioned the address as per the learned code below, is her register address in the judgment or any other records.
Where you're saying office note? Where is the office note? 9. If address is proper, it has been served. Because once in 16/5/2024, one notice there, on which date it was written unserved, with a report that not found.
Actually, that is her proper address.
Yeah.
Actually, that is her proper address as per the learned code below record.
Yeah, take a fresh then. Because here the state is also not the party, because it's a case of 125 in fact. Because you have taken steps only on 4/4/2024. Take fresh one. Take fresh step once. We'll see to it. So you're for the husband or the
Husband.
I am for the husband.
Or against the quantum you have come, or against the quantum you have come, or what? Why you have come? Why the revision is here?
Revision is there. He had no knowledge. He had submitted the WOs, but that was not recorded. But that was in the record.
Order was passed.
Order was passed ex parte. Though he was appearing, he have submitted written statement. There is record in order, but that written statement was counted in the judgment.
Heard Mr. You are Mr.
H. Huya.
Heard Mr. H. Huya from the office note dated 6/5. It's not dated 16/5/2024. It is seen that the notice returned unserved on the respondent number 2. Written remarks in Kumar were not found. It is also seen that the service notice steps was taken for the respondent number 2 on 4/4/2024. Full stop. Accordingly, the petitioner is hereby directed to take right steps on the respondent number 2 to register the judicial process in its present and proper address. List the matter accordingly after 3. Try once, we'll see. If it's served, then it's okay.
Obliged.
My apologies, Lordship. Lordship, in item number 9, I was stuck in court number 14, so could not come. I was,
Okay, are you appearing?
my lord, I was appointed as an amicus in the IA. When initially they had filed an IA, there was an IA for condonation of delay. So I was
In that
appointed,
condonation, you are appearing as an amicus.
I was appearing. That has been disposed of. Now the appeal has been registered.
No, we are passing an order also for issuing notice.
Notice.
But just he said that you have already appeared.
Yes, I had appeared in the IA, so I can continue in the appeal also, if provided your Lordship also mentions this.
That's why I have reflected your thing is that you have already appeared. But we are issuing notices there. But if you on the next date, if you appear,
Yes, no.
then it can be
No,
continued.
I'll continue since I was already there in the IA.
My lord, may reflect that since his name is already there in the cause list anyway, he may be appointed as the legal aid counsel if your ladyship permits
For
it.
the FOXO.
Because he's already there anyway.
Okay, I have dictated this one. Will item number
9, my lord.
9. Okay, your name will be there.
Grateful.
Lordship,
Yes.
steps we have taken in this case, Lordship, service report awaited.
But when you have taken steps, still awaited. Because otherwise we have received this scan copy and all, na? Only. Achha, you have taken steps for fresh notice on 19/9. Hard MS Learned Council for the petition. It appears from the office note dated 19/9/2024 that the fresh steps have been taken for the respondent number 2. Sole respondent name. Respondent number 2. To register daily and judicial process. Full stop. Let the service be awaited till next date of list. List accordingly. Okay, we are awaiting for service till next week.
Obliged.
May I please, your Lordship, it's a matter of delay of condonation, Lordship.
How many days delay?
Notice may be issued 142 days.
This is the first date. First date or which?
No. It came up long back. Or 31/7, there was an order to praise for some time to implement informant. Then again, notices were issued on 21/8.
Ah.
And he had perhaps challenged the order of rejection. No, order allowing a petitioner to be impleaded as an accused, I think, in the proceedings. Against that, he has come. He has challenged an order allowing the appellant to be impleaded as an accused in the proceeding?
Already informer is died. Then his legal hair should be impleaded.
Acha, legal
No,
hair.
he's an
Legal.
accused. Your petitioner is an accused or informant.
Accused. No, informant. Informant is died.
Informant died.
Died.
Informant died. There is no requirement to implead the heir.
No, he has already quoted rejected.
It was.
Something is wrong.
Right,
I'm able to
okay.
understand. Is on.
Implement.
Instant case Abdul Ali Majumdar expired. ना informer है abated क्यों होगा accused महिला है abate है
No, what is this order? One or I was there earlier.
I don't have the
One,
copy.
no, one I was earlier disposed of. I
Huh?
criminal 738
अच्छा
of 2020. So this is the one on 21/8/2024. One order has been passed wherein someone has been impeded.
someone has been
Applicant is allowed to incorporate the name of Anwar Uddin Mazumdar.
अच्छा
Why this is done?
Anwaruddin Majumdar is otherwise his arraigned as petitioner respond number 2. I think the Abdul Ali Majumdar was the informer and he died. This is wrongly written as abated because abatement will come only in case of accused.
See this one? Yes. Police petition.
Abdul Ali Majumdar expired and his son Anwaruddin and daughter so-and-so are the witness in the connected juvenile case. As such, applicant by the application is praying for implement of Anwaruddin and Nessa and daughter of informant late so-and-so, son and daughter, as party respondent 2 and 3, respectively in connected, preferred by so-and-so. Preferred by the applicant under section 5. Yes, it is seen that Anwaruddin and legal heirs, necessary parties, they were impleaded. They were impleaded as respondent number 2 and 3, son and daughter of the expired informant. This is what the order of.
Where impeded? In this case or in the original case or where? In this case.
In this case. Now, after this order, he had to file an impleading application by which it will be impleaded in the main case. Because nowadays the procedure is after this order you have to file a impleading application. Impleading nahi, some IA. There is something, some format is also there in the Guwahati High Court rules.
But why the
names?
The revision?
They are impleaded as party respondent number 2 and 3 in the connected IA criminal 681. 681 কোনটো condonation.
Condonation.
তেতিয়াহ'লে তুমি ইয়াৰ পিছত এটা এপ্লিকেশ্যন লাগে কোনটো এইটো 681 Planet Council with 1 week time to implead other respondents. Hey, application from Piper. Because Lordship will know after the court allows the impleadment of parties, the petitioner has to file one application. Otherwise, it doesn't come by its own. That application is there. Achha. After this order, Manas the order to Kittier type. This is 31/7/24. 8 to 21/8/24 include koi le dekho. This order goes. Order is Manas Justice Manas Patapar. here, your lordship has allowed you to 1 week complete auto respondent. But this is done. It is now allowed. It is now allowed. Now you have to file one application for bringing those name in the cause title. For bringing the name in the cause title, he has to file one application. Otherwise, his impleading application is allowed. So now he may file an application for bringing those name in the cause title. As far as my knowledge goes.
Otherwise, also you are for the accused, no? So you have been implemented subsequent. Against that implement order you have
Already
Yes.
implemented, Lordship.
Pardon?
Already implemented. And now it may be taken admission hearing.
Huh?
Admission hearing, Lordship.
No, not we are not on that. You are implemented as an accused by order dated 26/9/2023. That has been you have been implemented under 319.
It means Lordship not already case is decided.
Decided.
Five
Oh,
minus
then
6.
I got the judgment also. I don't know. I'm not yet to
Question
understand.
is that there is already 5 years accused and they have convicted in 10 years. Only the juvenile one is there. And 1 or 2 witness also state he is also there. He is 14 years old. Then court and implead him in this petition. Said he has go to the juvenile court and but as per law,
Your accused petitioner is a juvenile.
juvenile
He was implemented as a accused now.
due to the
Now his case is pending before
statement
juvenile.
of witness.
Obviously,
But
there are many
according to
cases.
law, after declare the judgment, nobody can implead. It is my petition.
But I think in their case it is filed or something.
No, on 26, it is a file between it has come to notice that your name should be there. in fact.
Means I just challenge the page 24, 25, Lordship. Page 24, 25. Main case is session case number 85, 2016, Lord.
And that is disposed of.
Yes.
After
Main
clear the
session
judgment,
case has already been disposed of, but while
already
preparing the
disposed of.
judgment,
Session
it
court
has
is
come to the
already
notice of the court that you should be one of the accused,
The-
but as a juvenile.
juvenile.
You are the juvenile. So
Therefore,
your name
juvenile
has been sent to the juvenile court, and now your case is pending. That is the case. Because court, while perusing the entire case record and all, the court finds that you should be there. Though you may be a juvenile, but you should be there. So you have been implemented. And the matter has been sent before the juvenile. Now he is pending before juvenile court.
My question
So
is,
you are facing trial in the juvenile now.
but according to law, I cannot.
Huh?
According to law, Lordship, after declare the judgment, nobody can implead.
No, while preparing the judgment only you have.
I have, but today I am not.
It was not declared at that time.
Judgment was declared on 9/11.
9/11.
23. And these orders are of 26/9 and 10/10.
Yes.
Lordship, question is that 319 section CRPC is applied here. 319 cannot apply, Lordship.
No, at any stage it can be.
Hmm.
Anyway, we are not on. So now your impleadment part is over. Now why this one? IA 681. Why 681 is here?
681 is accepted, Deheri, no?
And also-
for impleading. 681 is impleading only.
Applicant shall be
It is implement.
So newly implemented.
Just a condemnation.
Impleading. Now he has to file an application for airing those parties as respondent. In 681. Impleading. Impleading like some other.
So in 681, 681 is still pending. Why? It's not.
Delay of condemnation, Lordship. And
It's a
delay
delay of
just-
condemnation.
Lordship.
No, 681.
No, 681 is delay of condonation.
Delay of condonation. Delay of condonation, that I have not.
So, ulta pulta koro.
Mm.
No, 681. Lordship had just sent me. This is on impleading application.
No.
No, other one is 681.
Are you to keep?
No.
Condonation of delay. And now 681 to 6. Or 681 to Pamslan. Acha, 681.
681 is delay of condonation.
এটু কি
একটু ডিলে এই যে মানে নামটো না তার কারণে এই ইমপ্লিট করা
681 is condonation of delay.
ডিলে
No, condonation of delay.
Delay.
Yes. Okay. There's 142 days.
That where is 2 and 3?
681.
No, 2 and 3 is not there. No?
2 and 3 is not there. So he has to file one application, as I said. Only then those names will come in the cost file. আরো কলকাতা থেকে কলকাতা
Hard Mr.
এখানে
Alamgir.
allow is an
Alamgir.
কিছু বানাই যেটা
Hard Mr. A.H. Alamgir, the land accounts for the and also Hard M.S. Jahan, the land
ভালকে রেকর্ড
content. I to
এনে নিয়ম
from order dated 21/8/2022, it is seen that respond number 2 and 3 are the newly included in this case, whereby the petitioner was also asked to take steps under respondent number 2 and 3. However, it is seen that no amended cost that has been filed by the petitioner till date. Accordingly, the petitioner is hereby asked to file the amended cost status, impeding respondent number 2 and 3, and also to take steps on the respondent number 2 and 3, who are the newly included respondents. List a matter after. Have you taken steps? After that order, have you taken steps for respondent number 2 and 3?
No.
No, not yet. So you file the amended cost title for the impeding respondent number 2 and 3, and also take steps.
It is right.
This is what amended cost title. This he has to file.
Obliged.
May I please, Your Honor?
Yes.
Your Lordship, I am on behalf of opposite party number 2, and we will file an objection regarding this.
Opposite party number 2.
Yes. The
petitioner is not there.
I have not seen.
তুমি এটা
Can I appear?
আর চক্রবর্তী
Can I appear? First date order. আগতে appear হচ্ছে। আগরা এটা।
আর চক্রবর্তী
Yes. It editing. Already. Yes.
আচ্ছা
For desperation. This one is already been disposed of. Let's go for it. Then what is this? For expeditious hearing for connected criminal defense. Like the So this has been filed by you only?
Yes, sir. No, Your Honor, I have filed the criminal revision petition, and the respondent side has filed this I, whereby they have mentioned I have to furnish some documents. They have mentioned that they have not received any compensation. Already in the criminal revision petition, already 20% was awarded, and that was paid to them already. After that, they have filed this. It was in the admission. It was listed for admission, but it has not been listed yet. For that, they have filed it, and here they have mentioned that they have not received any compensation amount. For that, I have the document that we have filed. We have given them the
So now
compensation.
you're saying that in criminal litigant petition, you're going to file your objection. You have
No,
already
your
filed.
lordship, in the IA, I'll file the.
In the IA itself.
Yes.
The IA is no, like, IA is for only expeditious.
Here they have expeditious. They have filed it along with that in the page number 5, your lordship. In point number 6, last part, they have mentioned that they have not received any. For that reason, they want to expedite the matter because they, in the last part, however, the applicant oblique respondent number 2 has not yet received any compensation amount from the accused petitioner till date. The applicant has been facing extreme. For that reason, we are filing that. We have to give the receipt.
Now, see, simple question is that this petition is they have only filed for expeditious disposal of the criminal connected
Yes.
criminal negligence petition.
Yes,
So if you have anything, file it before the criminal negligence petition because this is for expeditious disposal. That much only.
Yes.
And in that context, those things were actually
Yes.
incorporated there. That
Yes.
they are not getting any compensation and all
Yes.
that. So if you have anything to say, you can say in the disposal. I mean criminal negligence petition. You can file your objection. But here this one for expeditious disposal. only.
Yes,
But they are not present today.
they are not here present.
R. Chakraborty is not.
Who is there?
R.
R.
Chakraborty.
R. Chakraborty. This the non-appears for the petitioner side. Heard MS. You are MS.
RR Muzi.
RR Muzi, the learned counsel appearing for the respondent, and also heard MS El Jafar, the learned appearing for state respondent. Ms. Mujib, the counsel for the respondent, submitted that she has the respondent will file their written objection to stop. In that context, accordingly, the respondent that they could file their connection with criminal litigant petition 360 list the matters accordingly after 4 days. So I have mentioned that if you have any objection, you can file in the
Yes.
written petition.
Obliged.
Please do. So this is an IA for suspension of sentence. At the outset, your ladyship, I'll point out one thing. There's a private respondent, but ladyship, in this case, I've had to bring in the private respondent out of compulsion. He's not required to be before your ladyship. In this case, the conviction is under 457 and 380. So this is housebreaking by night and attempt to theft. 511 is also there. The sentence imposed is 3 years under 457 and 2 years for theft. Now, rightly or wrongly, your ladyship and my learned senior will also tell this honorable court probably. In the appeal, that was filed before the sessions court, the informant was made a party respondent. Now, ladyship is well aware because the party was there as a respondent before the sessions court. I, as out of compulsion in this revision before your ladyship, I had to make him a respondent. Now, the situation is thus, your ladyship, that before the sessions court also, this private respondent did not appear. Before this honorable court, when the delay condonation petition had come up on the last day, the delay was condoned without the presence of the private respondent. Now, your ladyship, 458 days have been undergone in custody. Now, what is left is 1 year and 9 months. Of a sentence of 3 years, that is what is left. Your ladyship, I'll only...
Respondent number 2, he's the
Is
informant.
the informant. Your ladyship, the rest, issuance of notice, and I'll leave that to the wisdom of this honorable court. Only one paragraph, your ladyship, at page 39 of my IA, if your ladyship will kindly have that. This is the discussion of the learned magistrate's court in relation to the mitigating circumstances while sentencing me, your ladyship. Only a small part, your ladyship, at the end of that page. If I may read the last paragraph, 4 lines from the top, your ladyship. We note here, your ladyship has that.
Yes.
We note here that the intention of theft is necessary for attracting longer punishment under so and so. Actual commission is not warranted in such a case. It is the intention to commit theft with which matters. The convict clearly had such intention. Therefore, offence committed by accused under 457 of IPC attracts punishment up to 14 years. considered the young age of the convict and his residence at so-and-so, which is a backward village under Mikirvata PS. Economic condition of the convict is also poor. He has failed to appoint a private respondent to defend his case. All of these considerations gives an inference that sentence on the lower side is fit and proper. Even before your leadership today, my client, your leadership, has not engaged in any private counsel. We represent an organization which takes up pro bono matters, your leadership, by the name of Studio Nilima. That is pleaded in our application as well. Now your leadership will see that Annexure 3 to this application, they are documents relating to two young children, two very small children of the applicant, who also are, your leadership understands, their condition emotionally and mentally is affected because of their father's imprisonment. So I only humbly pray, your leadership, that some leniency be shown in this matter, and leadership would either consider allowing this application, or your leadership, in case notice is issued, a very short returnable date may be given, and the notice may be issued through the OC of the police station, your leadership, if at all.
So your conviction is under 511 and 380.
511 read with 380, that is one, that is for 2 years, and section 457 for 3 years.
457 is also.
457 for 3 years.
Otherwise, apart from POXO cases, in other cases, there is no requirement that the notice has to be served.
He is also submitting.
Yes.
Right?
In fact, he is pressing on the IA. So IA lordship can consider even in absence of those responses.
Yes.
This is not a POXO 376 matter. For 3 years, I think it's concurrently only.
Yes.
3 years, 2 years. So
Concurrent or consecutive? Is there any?
concurrent
The
has
issue
to
is, your
be-
leadership, the sentence is silent on that.
if it
both
is
the
silent,
magistrate,
if it is silent, then it will be consecutive.
both the magistrate's sentence and the that is also something that we have taken in the revision as a plea, that the sentences are silent on that.
Sentences are silent, then lordship knows it's consecutive. The provision
Leadership
31.
will contest that insofar as both, there has to be a discussion about whether it is consecutive or whether it will run concurrently. For either of those, there has to be some reason which is provided. Neither of the courts have provided a reason, really. Why should it be consecutive? Why should it be concurrent? Nothing is. The learned magistrate, to his benefit, has discussed that probation of offenders will not apply. Yet there is no discussion regarding concurrent or consecutive running of sentences. And leadership, even then, even in that case, even if the learned PP submission is ceded to, my humble submission is, your leadership, that in this case, because of the small sentences under both the sections, leadership will kindly take an empathetic view because of the clear circumstances.
Otherwise, in regards to the evidence and all.
Yes, your leadership. There is material contradiction between the evidence of both the eyewitnesses. Your leadership, I'll show your leadership from the judgment of the Sessions Court itself in the appeal. Your leadership will please have page 21 for a moment, para 8. Leadership has para 8. Now, leadership para 8 is a discussion of PW5's evidence. PW5 is the second eyewitness. Now, fourth line from the top, your leadership. On the said night, the incident, he along with PW1 were performing duty as watchmen of the shop situated at so-and-so. He further stated that they were engaged by shopkeepers of the area on wages. During the duty, on the night of the incident, they heard sound in the shop of Faizul Haq. Your leadership will please mark this. Now, your leadership, the evidence of PW1 is the exact opposite of this. There, your leadership, PW1 says, and this is just in the paragraph above, your leadership. Just in the paragraph above, same, page 21, just above paragraph 8, that is PW1's evidence. In the middle of that paragraph, your leadership, accordingly, leadership will find accordingly. Accordingly, on the night of the incident, when they were performing their duties, they noticed that the accused appellant entered into the shop of Faizul Haq by breaking the door frame. So one eyewitness is saying, in fact, what had happened is, before the magistrate, the deposition by PW1 is that we were hiding behind the bush near the shop, and we saw that he broke the bottom of the shop. The next eyewitness comes and says, no, we were doing our rounds and we heard some sound. So my submission is, leadership, to establish housebreaking by night, there has to be cogent eyewitness evidence to say that there is actually breaking in by the accused person. That itself is not their leadership. There's no other witness. Everybody else is hearsay. They've come after the factor. They're not even, there's no res geste also. And these two are not the informant. The informant is the owner of the shop who comes in later at the call of PW1. So, Your Ladyship, the primary witnesses, sterling witnesses of the prosecution have contradicted themselves in their evidence. That is my submission on the merits of the case, Your Ladyship. An attempt to theft is not there because there is no allegation by either of these PWs that some attempt was being made to carry something out or to do something. They said that he was rearranging something on the table. That cannot, in my humble submission, amount to theft, Your Ladyship, or attempting to steal something. It is not that they found something in the pocket of my client or something of that sort. Nothing of that sort has happened, Your Ladyship. And therefore, the entire inference which is drawn by the learned magistrates court and the honorable court below, Your Ladyship, in my very humble submission and with great humility I submit, is perhaps erroneous, Your Ladyship. It has to be set aside in this honorable court's revisional jurisdiction. So on merits, that is my case, Your Ladyship.
Yes, please.
Yeah, I think of course, on the merits, as far as consecutive and concurrent goes, it is given in section 31. If it is not written as concurrent, then the thing has to be consecutive.
But there
And
is
it
no
means-
reason.
Huh.
They have not.
So perhaps prima facie it will be a consecutive sentence. Now, how far it's correct, that will be seen later. Now here, if had it been 3 years, 2 years, Lordship would have given him bail, suspended his sentence. But now it will come to around 5 years. So 5 years, appeal can be heard in my humble submission. So we will have to go into the merits. So merits, Lordship, PW, I think I'm yet to go into the positions of the witnesses. What PW1 perhaps is the, he can make the corrections required. PW1 is the chowkidar, it seems, right? So he said that he heard some sound. He was a chowkidar, 3 or 2 chowkidars were posted by the owner. And so here PW1 said that he heard some sounds. Now it is possible that eyewitnesses, Lordship knows that if there are 2 or many, there can be some changes in each of them. One may be loitering, one may be standing somewhere, one may be sitting somewhere. So they might have seen the occurrence in a different perception, different ways. So PW1 said that he heard sound. Then PW2, I think he is the informant. He is not the chowkidar. He has appointed the chowkidars. PW5 perhaps is the chowkidar, right? So, and PW3, Lordship will see, accused person tried to enter. In the year so-and-so, he tried to enter. PW3 is also a chowkidar.
He's a hearsay witness.
Oh, hearsay witness. Lordship, we can skip it. And then PW5, Amiruddin told that the occurrence took place so-and-so. He and Dildar Hussain were working as duties, were doing duties as chowkidars. They have been appointed by the shopkeepers. They got sounds from this shop of Faisal while they were doing duties. He and Dildar saw switched on lights at his shop. Bottom of that shop was broken and they got sound while it was broken. Accused has entered into shop to commit theft and they caught him. So the issue is that they caught him red-handed. And then they informed the shop owner first and many other people. People assembled there. Gabura also came. So had it been only hearing sound, oh, okay, the matter would have been different. Here they caught him, what PW5 said. And we'll go into the nitty-gritties during the hearing. Here, prima facie. So 1 and 5 were there. 1 heard sound. 5 said that we both went and then we caught him. Subject to what he says. I have not gone into details. All the.
I agree with my learned senior Manoj. Only on prima facie, on a bare glance of the evidence that I am also submitting, Your Ladyship. Because if a threadbare analysis of all the evidence is done, then there are a lot of loopholes, Your Ladyship. The Batam they said was broken. It was never recovered. It was never seized. What was broken? To establish that I've broken into something, something has to be broken. The house breaking will only occur if a lock is broken, if a Batam is broken. The IO was examined as a witness. He did not seize anything in it. And he has admitted in his evidence, in his cross, that I did not see anything being taken or I did not find anything on the body of the accused person, of the petitioner before Your Ladyship. Ladyship, the only other small thing, there's a judgment that I placed before Your Ladyship, the Supreme Court judgment 1999 4 SCC page 421. In this judgment, Your Ladyship, I seek to rely on paragraph 3 in relation to my application. If I may read, Your Ladyship, paragraph 3 of this judgment. Ladyship will kindly see. When a convicted person is sentenced to a fixed period of sentence, and when he files an appeal under any statutory right, suspension of sentence can be considered by the appellate court liberally, unless there are exceptional circumstances. Of course, if there is any statutory restriction against suspension of sentence, it is a different matter. Similarly, when the sentence is life imprisonment, the consideration for suspension of sentence could be of a different approach. But if for any reason the sentence of a limited duration cannot be suspended, every endeavor should be made to dispose of the appeal on merits, more so when a motion for expeditious hearing of the appeal is made in such cases. Otherwise, the very valuable right of appeal would be an exercise in futility by efflux of time. When the appellate court finds that due to practical reasons such appeals cannot be disposed of expeditiously, the appellate court must bestow special concern in the matter of suspending the sentence, so as to make the appeal right, meaningful, and effective. Of course, appellate courts can impose similar conditions when bail is granted. Now, in my matter, Your Ladyship, another important factor is when the appeal was pending before the Learned Sessions Court, I was on bail, Your Ladyship. I was in prison only during the trial that was going on. So initially, Your Ladyship, from 18th of June 2017 to 1st of December 2017, I was in custody. Thereafter, during the pendency of the appeal before the Learned Sessions Court, I was out on bail. And then, Your Ladyship, only on 6th of December last year, after the appeal was disposed of by the Learned Sessions Court, I went back into custody. So this is a case, Your Ladyship, where I've been on bail. And even if today Your Ladyship considers releasing me, suspending my sentence, even then Your Ladyship is very well aware that conditions may be imposed. And I'll comply, Your Ladyship. I do not have any other alternative. I'm a very poor person, Your Ladyship. I have 2 young children to maintain, and a wife also. Those are my submissions before Your Ladyship.
I leave it to your lordship. Again, consecutive concurrent will have to be seen.
Yes, Your Ladyship. That
If it is 3 years and 3 years, this matter is not heard, then it will be creating injustice to
yes.
leave it to your lordship.
Heard Mr. A. Gautam, the learned counsel for petition, and also heard Ms. L. Jahan, the learned additional PP appearing on behalf of state. It's an interlocutory application filed under section 450, subsection 2, related section 442, subsection 1. You are quickly available of BNSSS 2023, corresponding to section 389.2. Related to section 401, subsection 1 of the Code of Criminal Procedure for suspension of sentence of conviction and release the accused appellant on it's subject by Mr. Gautam that the by all judgment and order dated 12/7/2023 by first by Learned Session Judge Morikawa in Criminal Appeal number 38 of 2017, affirmed the order and sentence dated 25/10/2017, passed by Learned Session CGM Morikawa in connection with case number 154 of 2017, whereby the present accused appellant was convicted under section 457 IPC and 380 IPC, rated section 511 IPC, and sentenced to undergo 3 years SI for section 457 IPC and 2 years SI for 380, rated section 511 IPC. It's submitted by Mr. Gautam that there are sufficient contradiction in the evidence of the PWs, and sufficient other loopholes of prosecution, and thus there is every chance to succeed in the connected criminal division petition. He further submitted that out of 6 numbers of witnesses, PW1 and PW5 claimed themselves to be the eyewitnesses of the prosecution case, but from the perusal of the evidence, it can be seen that there are contradicting statements made by both the eyewitnesses. As per PW1, he saw the accused appellant entering into the shop for committing theft. On the other hand, as per PW5, he only heard the sound in the shop of one. Whose shop was there? It was
PW2 village, Paijul Hub, informed.
Paijul.
Yes.
Shop of Paijul Hub. Apart from that, then of course, further is subject that the accused petitioner is behind the bar. Since when how long he is now?
458 days.
He is behind the bar since 458 days, and considering its period of detention, his prayer may be considered. Further, he submitted that during the entire during the trial of the appeal before the internet session judge, the accused appellant was on bail and he never jumped for any condition of the bail while he was on condition of the bail. It is prayed that prayed for suspension of sentence till the disposal of the connected revision petition, and also pray to allow him to go on bail. Next paragraph. In that context, MS S. Jahan, the learned additional PP, submitted that the PW1 and PW, there are some contradictions between the PW1 and PW5, but both apart from the evidence on record, in that the accused appellant was caught red-handed while he was found entering into the shop of the PW2. Further, she submitted that the accused appellant was convicted under section 450, sentenced to undergo SI for 3 years for section 457 IPC, and another 2 years for section 380 read with section 511 IPC, but there is no mention about the sentence, whether sentenced to run concurrently or consecutively. In that context, MS Jahan submitted that when there is no mention, it may be considered that the sentence are to run consecutively. However, she submitted that these are the matters to be considered at the time of the final hearing of the criminal revision petition. Next paragraph. No. আপুনি এটা কাম কৰিব, এই জাহানৰ যে সাবমিশনটোৰ আগতে তেখেতৰ আৰু এটা সাবমিশন Mr. Gautam further relied on a decision of Honorable Apex Court reported in 1999 4 SCC page 421 and emphasized on PETA 3 of the said judgment, which read as under next paragraph. Considering the submission made by the counsel for both sides, considering the entire matrix on record and other aspects of the case, vis-a-vis the conduct of the accused petitioner and other aspects of the matter, I find it difficult to allow the present petition suspending the sentence imposed on the accused appellant by judgment and order dated 12/7/2023 and 25/10/2017, passed by learned additional session judge Morigaon and learned additional CTM Morigaon till the disposal of the so and so. Further, the accused is hereby allowed to go on bail for rupees 20,000 with one security to the satisfaction of the learned additional session. your petition is allowed.
Very grateful, Your Lordship. Very good.
Obliged. To main criminal revision petition. In revision petition, what is the position now?
In revision petition, Your Ladyship,
Call
come
for
up
the
with the
LCR.
first occasion after the IA was allowed.
No, anyway, LCR was.
The LCR has come, Your
There
Ladyship.
is here, so in
LCR.
single benches, there is no requirement for paper book.
No.
It will be taken up in its
Yes,
usual course.
yes, yes.
ৰিভিজন পিটিশ্যন যিটো আছে তাতে আপুনি লিখিব মই এটা চিম্পল ব্ৰেক এটা ল'ব 5 মিনিটৰ কাৰণে এই যিটো ৰিভিজন পিটিশ্যনটো আছে তাত লিখিব হাৰ্ড ডিষ্ট্ৰিক্ট এইট বটন দিছ এণ্ড ছ অলছ' হাৰ্ড এম এছ জাহান ছ এণ্ড ছ LCR has already been received. List the matter according to filing. It will be listed for it.
I'm grateful. I'm grateful.
All right.
Don't want to press the IA. That was the instruction.
Yeah, next date you
Miles. Obliged.
do 0.
May I please, Your Lordship? Lordship, this IA has been filed for withdrawal of the amount which has been deposited by the petitioner as per the order dated 6/3/2024.
Six 3/24.
Yes, my lord.
In this IML,
20% of
20%
20%.
already deposited, but in the order malert, there is no order for releasing that amount. It is NI Act matter malert.
Yeah, obviously an act.
Yes.
Then better to place it by the court which has already been passed the order because may not be there may be some intention.
And in that stage, if your lordship allow, then only my submission is this one malert undertaking.
No, I do not interfere this time.
Yes.
Yes, but because there is no sentence that
Yes.
he may be at liberty to withdraw the same. Obviously, as per the order, 20% on the basis of that stay has been passed.
Yes. And
Let be appropriate bench only, then it will be most probably easier. The court which has already passed the order, it is simply IA to click, IA to click. List before the appropriate bench. Do you want any after vacation, before vacation?
After vacation?
After vacation. List before appropriate bench after vacation.
If it's convenient, then it may be before puja vacation also. It's
Before Puja.
before puja. A date may be
Puja
fixed,
any
my
date
lord.
kiba ase. Sabko tini mas sari kiba.
4 malert, I am not available.
30
30.
September.
30 is before the appropriate bench, not 30.
Obliged.
Deeply obliged.
May I please, Your Lord?
Yes.
My lord, in this case, my lord, as per order dated 17/7/24, my lord, we were directed to implead the Director of Secondary Education, as respondent number 2, to this criminal revision petition, my lord.
Order dated
17/7/24, my lord.
17/7.
24, yes.
Yes.
Yes. My lord, the facts of the case are such
So
that
you are directed to implead Director of Education as
respondent number 2,
So this is the petition.
yes, my lord, IA number 890/24, my lord.
You are appealing for the respondent number
Respondent number 1
1.
on behalf.
Do you have anything to say? No.
Lord, may I pray that the step may kindly be taken by the respondent number 1, my lord, because she'll be getting the benefit. My lord.
So I'm not following what you said.
Lord, the steps may kindly be taken by the respondent number 1, my lord, because she'll be getting the benefits, my lord,
No, order is
Yeah.
Benefit? Mean?
My lord, the facts of the case are such that the petitioner husband was working at a school that was under the elementary education department.
Hmm.
And accordingly, my lord, the learned SDJM directed the petitioner and directed the block elementary education officer to deduct a portion of the petitioner's salary and give it to the respondent wife. Subsequently, my lord, the petitioner's school that he was working at, it got amalgamated, and now it comes under the secondary education department. So, my lord, now we have implemented the secondary education
So
director.
why you're saying that he will beneficiary or whatever? Question is that you have implicated him as a party,
Yes, ma'am.
the department.
Yes.
So we have to take steps.
in the order. It
Okay,
is also,
ma'am.
my lord.
Ma'am.
It was directed to petitioner.
So, my lord, we'll
The
take the
last
steps,
order
my lord, no issues.
Last order also.
It was directed to petitioner to.
This obviously it will be steps.
My lord, we'll take the steps, my lord.
You are Mr.
S.H. Mahmood.
Heard Mr. S.H. Mahmood, the learned counsel for the petitioner, and also heard you are Mr.
S. Chaudhary.
S.
S. Chaudhary.
A.S. Chaudhary
Good.
for the respondent one.
Respondent one on behalf of A.W. Aman.
For respondent number one, appearing on behalf. Here, Mr. S.A. Borvia is there.
S. A. Borvia, yes. My name is not in the.
No, you are appearing for A.H. Aman.
S. A. Borvia.
S.A. Borvia. এখানে নাম তো লিখে দেন। Also appearing on behalf of Mr. S.A. Borvia for the respondent number one. Stop. This is an application being for implement of opposite party number two and being for implement of the Director of Secondary Education, Assam Kahlipara, as respondent number two, by order dated 17/7/2024, passed in criminal revision petition number 283 of 2020. It is submitted by Mr. Mahmood that by the order dated 17/7/2024, the petitioner was directed to impede the Director of Secondary Education, Assam Kahlipara, as respondent number two. Respondent number two. Mr. So the council appearing for the respondent number one, raised no objection. They are allowed. Accordingly, the present petition is allowed, implementing the respondent number two, implementing the Director of so and so as respondent number two. The petitioner will do the needful in filing the amended cost-title in connected criminal revision petition number 283/2023, and will also take steps to register the eligible process for the respondent number. With the above observation, the I stands to our criminal revision to differ, are so and so. In view of order, hard so and so criminal revision to in view of order passed in IA criminal file 8/19/2024, the petitioner is thereby directed to file the amended cost and also to take steps on the respondent, newly implemented respondent. Is the matter of revision.
Much.
May it please your lordship.
Yes.
This IA is for condemnation of DLO, my lord. The condemnation of DLO of 4 days may be condemned, my lord.
4 days.
4 days only, my lord. Primarily because of the fact when the impugn order which has been assailed in the criminal revision petition was passed, then the applicant was under treatment and bed rest, my lord, and therefore she was not in a condition to contact with her advocate, my lord. And after getting a little recovery, she tried to know about the case status, and she came to know that on 31/5/2024 the impugned order was passed, which has been challenged in the criminal revision petition, my lord. Thereafter, she applied for the certified copy. Accordingly, she received the certified copy. Thereafter, my lord, she came before the advocate of Lakhimpur, and then therein she advised to come before this honorable court to file revision petition, my lord, and accordingly she came Guwahati and engaged us. And sometimes also, my lord, taken in drafting the petition. Therefore, my lord, 4 days was delay, my lord. My lord, I have annexed the medical documents, my lord. My lord may see page number 7, 8, 9, 10, my lord.
It was a criminal case. I mean, complaint case.
My lord.
Complaint case.
My lord. She was complainant in the case in the court below, my lord.
You are Mr.
J. Burman, my lord.
J. Burman.
My lord.
I heard Mr. J. Burman, the learned counsel for the petition. This is an application under Section 5 of the Petition Act for condonation of delay of 4 days in filing a criminal revision petition under Section 438, Section 442 of BNSS against the order dated 31/05/2024 passed by Learned GMFC Lakhimpur at Lakhimpur, not Lakhimpur, whereby all the accused persons as the opposite parties were discharged from case number CR W01 of 2018. It is submitted subsequent to Burma that during the trial of this case, the petitioner was not keeping well and she was under treatment. And after recovery only, she came to know about the status of the case. And then only she came to know that case has been disposed of and all the respondents as the petitioners, respondents as the were discharged from the scene. After collecting the certificate copy and all, she accordingly filed the connected revision petition against the order passed by the Learned GMFC Lakhimpur, not Lakhimpur, dated 31/05/2024 in case number CR W01 of 2018. Mr. Burman further already also annexed the medical certificates for the petitioner who was under the treatment at the relevant level, at the relevant. But considering the submission made by Mr. Burman, the learned counsel for the petition, other aspects of the case, also considering the days of delay, and also considering the no. And finding the no, and aspects of the case, and also for inch of the present petition is allowed, containing the delay of 4 days in preferring the connected revision petition. The delay is accordingly condoned. The registry is thereby directed to register the connected revision petition and put duty number. Registered and numbered the case as well. I to dispose of it. Okay, your petition is disposed of. Your other revision petition will be accordingly numbered.
My lord, I'm deeply obliged, my lord.
Affidavit excellent. This is your affidavit.
May I please, your lordship? This
No,
matter,
affidavit
lordship.
filed by you.
The affidavit is filed by me, respondent number 2.
Lordship, already matter has been settled, lordship, and allegations are under section 498(8), sheet 13, 506 to 94. And lordship, now they have settled the matter, and the victim is now residing with the petitioner, lordship. And therefore, lordship, the respondent number 2 has filed one affidavit that she has no objection if the FIR and charge sheet is quashed by this honorable court, lordship. This matter is
What is the stage of the case at present?
at present, lordship, appearance. Appearance
This is already charged.
charge sheeted, lordship, and date is fixed on tomorrow, lordship, and earlier stay order is there, lordship, in this matter. So, lordship, kindly quash the FIR and charge sheet, lordship.
If that be the position, you could have filed a joint petition also.
Lordship, joint petition, lordship, on earlier occasion, lordship, notice has been issued by this honorable court, lordship, and thereafter she had appeared and informant had appeared and filed one affidavit, lordship.
ये तो एक नहीं double an application to and that's what instance
528
to prayer Akko versus
Lordship, cost
episode black nine right Akko prayer. Excellent. Have you
Lordship,
seen your
this petition was
petition?
earlier filed under section 482
No,
of
no, no,
CPC.
whatever.
Earlier filed under
Earlier
section.
file is understood. Have you seen your petition?
Yes.
Have you gone through what you have filed? Let's see.
Later on, I was directed to file the petition. Oh, cost title has been changed.
No cost title, nothing. Oh, nothing is there.
Oh, page number to the amended case title. Mane? Huh? Court order. Earlier, I have filed one IA, Lordship, for changing the cost title. cost title BNSS or under delay code number 20 Mrs. Mita Baidu. Let's say to BNSS order. এইটো মানে যিকেইটা চেঞ্জ হৈছে সেইকেইটা আগত লগাই দিয়ে
মানে it's not in orders also. It's not in chronological order, pages and all.
Oh, মানে
That is the
সেইটো
issue.
বুজিছো
We just
এইটো
make it-
এইটো লাষ্টত মানে প্ৰথমত ভৰাই দিব বিচাৰে
এইটো
আকৌ সিহঁতে
second.
1 2 3 কেইটা খুলি দিলে তাৰমানে।
সেইকাৰণে অৰ্ডাৰটো কৰি দিওঁ।
এইটো
কালি
হেৰি
কৰি
ঠিক
দিওঁ।
কৰিছে বুজি পাইছে নে অফিচে ভুল কৰিছে এই দুটা লগাই দিলে কিন্তু
Your mail-
আগৰ 1 2 খিনি
আৰু 1 2 টো নাই আৰু।
খুলি দিলে চাগে
Some pages are missing also.
yes but এটা
Omuk and such and such versus nothing is there. Nothing is there.
pages are changed lordship and it was
don't
done
know
in
how
the
pages are
office
missing now.
lordship so lordship matter may come up after 1 week lordship I may be allowed to correct the same lordship office
Hard MS, MSG Deca.
G Deca.
Hard MSG Deca, the learning concept repetition. Also hard MS R Goswami, the learning concept appearing for the respondent. And MS SH Bora, the learning appearing on perusal of the criminal petition, it is seen that the petition is not in the proper order. The pagination is also not correct. And accordingly, the petitioner is hereby directed to correct the pagination and the form and the correct pagination of the present petition and to file the amended petition accordingly. The structure after petition. The structure. Was there any stay? Stay was there.
Stay was
Which date it was passed?
stay was passed on 10 September.
Stay order passed on 10/7. No, gym order passed on 10/9/2024.
No, stay asile 10 তারিখে দিছে
Most of the
বিকাশে
respond
ফোন
number
করে
is
কইছে
also filed there in opposition. Keep it in this record. We listed after vacation.
Obliged.
Otherwise, it could have been disposed of today.
Yes.
Yes, Lord.
It's a good case.
Yes.
Item number 20.
May I please, Your Lordship, I'm on behalf of the petitioner. Actually, today the matter may be passed over for the day because the senior counsel, while coming to the court, he met with an accident. That's why.
He made it an accident.
Yes. Suddenly he fell down actually due to low blood pressure.
Yes, what is it?
That may be adjourned for the day.
Yes.
After it.
Considering the
January
prayers in the dinner.
January 6th. January 6th. Date fixed করলে পরে date may be fixed, Lordship.
Year Medi. You're from Mr. K Medi or Year Medi?
I'm K Medhi on
Your
Lordship.
yes, you're for you're K Medi.
Yes.
And who
On
is
behalf Air Medi.
Air Medi, no?
Yes.
MS MS K Medi on behalf of Mr. Air Medi. It will be obviously come after vacation then.
It may be fixed
In the month of
because
November.
it is fixed in January in lower court, trial court.
Let the matter maybe come up in the month of November. Mid-November.
Month of
November.
Date
November.
Yes.
13.
1/3.
Much.
May I please, Your Lordship? Lordship, LCR not received.
LCR? Your LCR not received?
Yes.
No, that is not reflected in the cost. So, LCR was earlier called for. LCR called for is call for the LCR.
Meanwhile, call for the scan copies.
Yes.
Now you want the LCR or scan copy?
Scan copy of
LCR.
LCR. Yes.
Heard Mr. Spence, returning counsel for the petition, and also heard MS SH Bora, returning petition PPFA on behalf of J. From the office note dated 20/09/2024, it is seen that the scan copy of the LCR is not yet received. Issue reminder, please to take necessary steps. Please demand of the courts. So So issuing reminder this time.
Lordship.
Now, hearing to low lap no hope. After petition. Hearing to no hope. Hearing was there, na?
Yes, yes, well.
But the question is that I'm not in a position to take the hearing matter because this bench is continuing up to 1 only.
Yes, well.
From
Not
2,
take
I
time.
have a division bench.
It will not take time, but it is
No,
behind.
no, not take time is a different thing because half an hour
It
it may
can
not
be fixed then.
POCSO matter, her statement has to be seen. And again, I think he'll raise on the age issue, raise the issue of age of the victim.
Because from
We fixed, my lord.
actually from 2, I have a
4th of
But it
October,
takes
my
some
lord.
time.
4th of October, my lord.
4th of
That 22,
These are
22,
motion days.
22 October.
These are all the
He's
motion
behind bar
days.
2 for 2 years.
Yes.
22. 22 October.
22nd October.
22nd October.
22nd
22nd
Yes, ma'am.
informant has some difficulty.
Informant?
Has some difficulty.
24th.
24th of
24th.
No,
Yes.
what had happened actually, I don't want to get it parted also
Hmm.
because I have been division bench and also not sitting regularly, in fact. Otherwise, if it is parted, we can have posted it tomorrow. But tomorrow also, I cannot say the position. What will be the position?
Tomorrow Lordship
See-
is sitting in the morning half also with the
With division bench.
in division
Yes. That's why we are not in a position because half an hour most probably it may not be completed. That is the problem. Otherwise, your petitioner is behind the bar for 2 years. This is section 4 or section
6.
Section 6.
So we are raising made the age factor. There
10
was
years, no?
10 years.
10
but
years.
For 2019.
Age he will raise, I know.
Age is the main
Because
factor because the certificate, there was no certificate.
School registers are
School
there.
register, but they have not produced the original certificate.
And
Only they
under
had.
section 35, the headmistress and all were examined. This I will have to show. On 24th then.
On 24th then.
A lot.
So,
Lordship, item number 23. I'm sorry to disturb, Lordship. The pages are annexed in the last portion of
it's your job, it's not mine, na? Not the court's job. You could have said